rise for the jury.
Okay. There's somewhere here. Why won't do what I need to do? You may be seated. Oh, I forgot also. I'm sorry. I do need the jury to go back out. Just sit right there in the hall. I did forget one thing. Hold on. Okay, I did forget one thing though.
All rise for the jury.
All right, two things. So I don't know, Ms. Dixon must have misunderstood my yesterday, but let me read in the record. 6.419, motion for directed verdict. B, the court may reserve the decision on the motion, proceed with trial where the motion is made before the close of all the evidence, submit the case to the jury and decide the motion either before the jury returns a verdict or after it returns a verdict of guilty or is discharged without having returned a verdict. If the court reserves its decision, it must decide the motion on the basis of the evidence at the time that the ruling was reserved. I reserved my ruling. Furthermore, with respect to the defense's case, yesterday I was questioning the jury, questioning you, Mr. Johnson, with respect to your intentions to testify. And I said that I would give you an opportunity to rethink your decision or think about your decision, and I would question you again this morning. So, Mr. Johnson, state your name again for me.
Marcus with a K, Correll.
Sorry, quit spelling your name. We know how to spell it with a K. I want you to state your name for me.
Marcus Correll Johnson.
All right, and Mr. Johnson, you've had an opportunity to think about your decision that I started questioning you on yesterday.
Yes.
And is it your decision to testify or not to testify?
Not to testify.
And is that your individual and personal decision after consulting with your lawyer?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter or to give up your right to testify? Has anyone threatened you in any way or promised you anything?
Nobody promised me.
Well, what do you mean by yourself what you think? Because you keep hesitating, Mr. Johnson.
I know, sorry about that, Your Honor, but this is very confusing for me.
What's confusing? What's confusing?
I didn't do nothing. I'm sitting in the court of law.
What difference does it make? I'm talking to you right now about your decision to testify or not to testify. You're not the first person to be sitting in a court of law feeling like he didn't do anything, nor will you be the last. My question to you, sir, is it your decision not to testify. Has anyone threatened you in any way or promised you anything to get you to make the decision not to testify?
No, Your Honor.
Okay, when the jury comes back in, Ms. Stevenson, you need to rest in front of the jury. I'm ready for the jury.
Thank you, Your Honor.
Off the grass, move this waiter's, blocks off the. Thank you. She did all that talking, see, that's why we know. Just keep talking. All right. Jonathan, you may see it, everyone may see that, I apologize. And then, the people rested, at the end of the day yesterday. Ms. Stevenson, anything on behalf of the defense?
Defense rests, Your Honor.
Okay. Are the people ready for closing argument?
People are ready for closing.
All right, then, you may proceed.
Thank you, Your Honor.
Let me check.
You
may.
Thank you. Welcome back, ladies and gentlemen. So, ladies and gentlemen, you heard the testimony of Mr. Ray. Mr. Ray testified that on the day in question, May 23rd, 2023, he was working on his house and went outside for some fresh air. During that time, he testified that while he was standing on the porch, he noticed Mr. Johnson across the street in his house. And when he noticed Mr. Johnson stood up, reached into his right waistband, pulled out his gun, and Mr. Red did testify as to the description of the pistol. And he pointed it at Mr. Red and said, "I'm guilty." Now, ladies and gentlemen, again, yesterday when we were here, we all talked about this burden of proof that I had to prove. And the burden of proof is not reducing the facts, right? And that burden is high, but it's not unattainable. It's not out of reach. It's not a burden that cannot be met. And we all talked about the evidence that I had to provide in court for the meet that burden. Now, ladies and gentlemen, the evidence that I had yesterday was all the evidence for this case. That was the evidence that I submitted in court. Like we all talked about, I don't need to bring 100 witnesses or 2 boxes full of evidence to prove my burden. The testimony from Mr. Red yesterday was the testimony that was needed to meet all of the elements on these instructions for brandishing a firearm. You all will get a copy of these instructions in the jury room. I'm not going to read them all, but I do want you to know that every single element of the instructions has to be met in order for Mr. Johnson to be guilty. Now, ladies and gentlemen, if you're paying attention to the testimony from Mr. Red gave you each element in the testimony. All you have to do is connect the dots from the testimony to these instructions for the elements of brandishing a firearm. Now, ladies and gentlemen, again, if I had met all the elements on this instruction, then Mr. Johnson is considered guilty by your verdict if all of these elements have been met from the testimony. And I'm not talking about any evidence that wasn't introduced in the trial yesterday. I don't need to prove that a gun was recovered. That's not part of the instructions and the jury instructions for you. I don't need to prove that there was video. All I need to prove is each element beyond a reasonable doubt. And you got that testimony when Mr. Red testified yesterday on what happened on the day in question. So as long as you have the instructions, ladies and gentlemen, all you have to do is connect the dots. That's it. It's not a hard test. It's not a complicated test. You literally have to connect each dot to each element from the testimony from Mr. Red yesterday. And once you all do that, the people hope that you return a verdict of guilty for brandishing a firearm. Thank you for your time.
on behalf of Mr. Johnson.
Thank you very much, Your Honor. Good morning again, everybody. So let's go ahead and get to it.
Now, Ms. Dixon, you're not gonna be talking over things.
Let's go ahead and get to it so that we can get on to the next thing that we all have to do this morning. So I guess I disagree with what Ms. Ritter said, that you have to connect the dots, right? So I was thinking about last night, I'm going on and on and on about this stuff. And I had an image in my mind of doing a 500-piece jigsaw puzzle, right? So you have the puzzle and you're like, that's a pretty picture. I want to put that together. That ought to be fun. So you have the picture of what the puzzle is supposed to look like. You open the box and then you dump the pieces all over on the table. And then it's your job to kind of flip the pieces over and put together the dark blue, that's gonna be the water, and the light blue, that's gonna be the sky, and the green, that's gonna be the trees and stuff like that. That is similar to what Ms. Ritter is asking you to do today. She's put a picture up here of a charge and giving you the puzzle pieces and dumped them all on the table. And so now you put all that together, flip all those pieces over, get everything together, put the dark blue over here, the light blue over here, the green over here and all that, and then you put it together and figure out whether or not, see if you can turn this stuff right here into that. That's what the people have asked you to do. And that's not what you're supposed to do as the jury. What's supposed to happen is the evidence that's put forth on the witness stand and any exhibits are supposed to, she's supposed to put it in the scale, and the scale's supposed to come down, stop being like this in favor of the defendant, go like that. And that didn't happen. I submit to you that based upon the evidence that came forth, it is still unclear as to what's going on over there on Carlin Street between Mr. Red and Mr. Johnson. All we do know is that these people have lived across the street from each other for 7 years, and they have not had a cordial relationship. Mr. Red said, I don't really even know him. No, we haven't been friends or nothing like that. For 7 years, they lived almost directly across the street from each other and don't get along with each other for whatever reason, And then Mr. Red told you that he's sitting on he comes out of it onto his porch and he looks across the street and Mr. Johnson is in his yard, and that Mr. Johnson then pulls out this gun. Now, I am gonna read the jury instruction to you, and the judge is gonna read the jury instruction to you. The defendant is charged with the crime of brandishing a firearm. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant possessed a firearm or had control of a firearm. A firearm is a weapon that will shoot out a projectile by explosive action, is designed to shoot out a projectile explosive action, or can be easily converted to shoot out a projectile by explosive action. Second, that while possessing or controlling the firearm, the defendant was in a public place. Third, that while possessing or controlling a firearm in a public place, the defendant deliberately pointed it, waved it about, displayed it in a threatening manner. Fourth, when the defendant pointed, waved it about, displayed, he intended to produce fear. So Mr. Red told you that he was on his front porch and that Mr. Johnson was in his yard. So when did somebody's private yard become a public place? Now, and if we don't think about anything else, I think we're ready to go with that one. But let's say we want to go on a little bit further. Let's say we want to go on. There is a difference, we already talked about this and we're here, between proof and suggestion. There's a difference between proof and speculation. There's a difference between proof and accusation. And all you have by way of evidence at this point is accusations, speculations, innuendo, suggestions. All you have is Mr. Red, who sat in the chair and said, I was on my front porch, and Mr. Johnson was in his yard and he waved a gun at me. And so then, you know, we have Officer Ayala who takes the stand, and I guess, you know, more on this, you know, we can tell when a person's guilty. Guilty because I said you did something, now you're guilty. You're guilty because you ran from the police. Well, that's not what was going on. Officer Ayala said that he saw Mr. Johnson run into his house. He saw Mr. Johnson go into his house and do what? Call the police. How are you running from the police and you're talking to the police at the same time? How is that a suggestion or accusation, evidence, or anything, or of guilt? Judge Bryant asked a question about the car that pulled up, police car that pulled up. My kids call that an ox truck. That's different than the blue and white, or that's the police car that drives up. I know that's the police. I know that's a police car. There's no evidence that Mr. Johnson was trying to get away from the police because he was in his house calling the police. And Officer Ayala knew he was talking to the police when he came out, when Mr. Johnson came out, handed the phone to Officer Ayala. And Officer Ayala is like, oh, okay, we got him. I asked Officer Ayala who that was you're talking. First, Officer Ayala didn't remember, but then showed the video. And he's like, oh yeah, I remember. He was talking to police dispatch. You're not running from the police and talking on the phone to the police. That's evidence of nothing. None of that even matters. You know, we can get into what's missing if you want to do that, but you don't even have to do that. But I agree with Ms. Ritter. She doesn't have to bring buckets and buckets of evidence. She doesn't have to bring reams of paper. She doesn't have to bring videos and all that stuff. She doesn't have to put a whole bunch of witnesses on the stand. But what she does bring has to outweigh the presumption of innocence. It can't just be, this is what he did. And it can't just be, well, we think he did it too because he didn't come out the first time we told him to come out. They tell him on the loudspeaker, come out, we're gonna bust your door in if you don't come out. And eventually he comes out to the yard and they're like, come on over here. Come on over here. Don't give him a chance to say nothing. As soon as he comes out of that fence, they cuff him and get ready to start putting Mr. Johnson in the police car. And then Mr. Red comes to court as proof. He was in his yard waving a gun at me. That doesn't even meet the statute. I really am not sure as to why we're here. I disagree that your job is to connect the dots. Your job is to determine whether or not the people have met their burden of proof. Your job is not to fill in any blanks. Your job is not to be flipping puzzle pieces over and putting it all together and putting the people's case together. That's not your job. Your job is to determine whether or not they have proven their case. Not whether or not they've suggested that anybody did anything. Not whether or not anybody's been accused of anything. Let's talk about that stuff about Mr. Red talking about Mr. Johnson pulled a knife on him. Mr. Red is the one who brought that up, and then you can't even get more information about that. There's something else going on over there.
Well, I sustain the objection, Ms. Dees, and that's an inappropriate argument.
I apologize.
Thank you.
Your Honor. What you do know, however, is that there's something going on over in Carlin Street, and you don't have a clear enough picture of what happened on the date of this incident to find Mr. Johnson guilty. The suggestions, the accusations on the part of the witness do not meet the statute. The evidence that came forth, video, Ms. Ritter is right, she doesn't have to bring the gun. But something other than the witness saying this is what happened. A witness who has animosity, conflict, beef with his neighbor from across the street for 7 years. 7 years. Something else is going on over there. And I suggest, I don't know. The evidence didn't present enough information for you to know. But those accusations, the speculations, some of the jurors that they hang out with us, that they said they have this 6%. Now, I'm supposed to be using intuition, magic, psychic powers, and all, you gotta weigh evidence, and it's not here. And I'm asking you to find Mr. Johnson.
Rebuttal on behalf of people.
Yes, sir.
So ladies and gentlemen, as Ms. Stevenson put it, this is some type of conflict between two neighbors, and we all have neighbors, and we know the difference between conflict, a dispute versus a criminal. This is not a neighborhood or neighbor dispute. This is a criminal matter. And the people don't have a problem with individuals exercising their Second Amendment rights to bear arms, because we all have that right. The problem that lies before us today is the testimony that was provided to you yesterday by Mr. Red. What the people have a problem with is somebody possessing a firearm, pulling that firearm out on another person, pointing at that person and threatening to kill them. That's why we're doing that. It's not between the bickering of two neighbors. It doesn't have anything to do with the history of these neighbors. And what I find interesting is that yesterday we talked about the common sense and reason to reach that reasonable doubt, right? That fair, honest, common sense and reason that you all apply in everyday experience, right? And what I found funny yesterday is that during the video that was played from Officer Ayala, Mr. Johnson, when he noticed Mr. Red scream out, "There he is over there," he started to run. Now, ladies and gentlemen, I'm asking you to use your common sense. If you're the one waiting on the police, if you're the one who called the police, why are you running when you notice that the police are there? What's also funny is that Mr. Johnson ran into the house, and as you saw in the video, it took Officer Ayala to get on his PA system to tell Mr. Johnson to come out more than one time. Now, your reasoning and common sense should kick in at that point, and it should tell you that, of course, he had time to hide the gun in the house because that's where he went. Of course, he had time to get rid of the evidence and go back outside and nothing is on him because he went into his house. And then he's on the phone with the police. It doesn't make sense, ladies and gentlemen. It doesn't make sense that he was the one who called the police when he ran, when he noticed that the police were there. And that's all I'm asking you to do, ladies and gentlemen, is to use your reason and common sense in this case. Now, Ms. Stevenson pointed out that I'm asking you to put together some puzzle. I'm asking you to figure out the pieces. That's not what I'm asking you. I think I gave you more answers than I gave questions yesterday. I gave you the testimony from the complaining witness, Mr. Red. And during that testimony, he told you exactly what happened. He stood on his porch. He saw Mr. Johnson across the street. Mr. Johnson pulled out a firearm from his right waistband, pointed it at Mr. Red and said, "I'll kill you." Those meet the elements of brandishing a firearm in public. And that's what I'm asking you to do. The facts from the testimony I was given yesterday to the law. That's it. That's what instructions are for. It guides you to your answer. And that's your answer, ladies and gentlemen. That's why I'm asking you all to deliberate and come back with a verdict of guilty, brandishing and felony with a firearm. Thank you so much for your time.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law as it applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and the testimony, and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what the witness said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer said something different about the law, follow what I say. At various times, I have already given you instructions about the law. You must take all of my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the law are. It is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable. After a careful and considered examination of the facts and circumstances of this case, every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that the defendant did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witness, the exhibit admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you should be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's questions to witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you should pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding this case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a person, place, or event. To repeat once more, you must decide the case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyer? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any threats, promises, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Okay, I'm gonna just read number 4 anyway. Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider both circumstantial evidence and direct evidence. I read that wrong. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all of the evidence that you believe. You heard testimony from a witness that was a police officer. That testimony is to be judged by the same standards that you use to evaluate the testimony of any other witness. The defendant is charged with the crime of brandishing a firearm. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant possessed a firearm or had control of a firearm. A firearm is a weapon that will shoot out a projectile by explosive action, is designed to shoot out a projectile by explosive action, or can readily be converted to shoot out a projectile by explosive action. Second, that while possessing or controlling the firearm, the defendant was in a public place. Third, that while possessing or controlling the firearm in a public place, the defendant deliberately pointed it, waved it about, or displayed it in a threatening manner. Fourth, that when the defendant pointed, waved about, or displayed the firearm, he did so intending to cause another person or other persons to be fearful. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about May 23rd, 2023, within the city of Detroit and the county of Bryant. When you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own. You must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, ladies and gentlemen, have your foreperson write a note. Put it in the envelope and give it to the court officer without any conversation. If you want to communicate with me while you are in the jury room, please have you're a foreperson, write a note. Put the note inside of an envelope. Do not write on the outside of the envelope. Write the note, put it inside of the envelope, slide it under the door. The officer will be sitting right there, they'll get it, they'll bring it to me. Do not have conversation with the officer about the note. Whatever you want inside of that jury room, write a note. If it's too hot, write a note. If it's too cold, write a note. If you need to go to the restroom all at one time and there's only one restroom inside the jury room, write a note. Write a note. Write a note. If you need some water, write a note. Okay, write a note. Write a note. Write a note. It is improper for you to talk directly to the judge, the lawyers, the court officers, or any other person involved in the case. Write a note. Write a note. Write a note. Write a note. As you discuss the case, you must not let anyone, I'm included in the anyone. I know you all are saying, why does she keep repeating herself? Because the last jury, they just messed this up. Okay. You should not let anyone, even me, know how your voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside of the jury room. That means if you're in the jury room and you can't reach a verdict, and it's because 2 people are voting one way and 4 people voting another way, don't tell me 2 people voting one way and 4 people voting another way. Just say, Judge, we can't reach agreement. That's all. Judge, we deadlocked. Judge, we can't come to a unanimous verdict. No numbers, no statistics, no figures, nothing. Just that information. If you want to look at the exhibits, there were 3 videos admitted, and Ms. Ray, you didn't get our laptop.
Not to.
Okay. The other attorney that usually does felony cases, she had a laptop that she could send in to the jury room. So unfortunately, we don't have that. So if you want to look at the video, write a note and say you want to see the exhibits. And as you recall, I told you there were 3 videos and only a portion of 2 of them were shown. But if you, I don't know, for whatever reason, just want to see the videos or the other video, it's in evidence. There are 3 videos in evidence. But if you want to see the video, just write a note and we'll bring you back into the courtroom and let you see the video. You will also, when you go to the jury room, you will be given a written copy of the instructions. And normally I would give each individual juror their own jury book, but my regular court reporter is not present and she usually gets my jury books ready. So I'm only going to make sure one of them is correct and then you all will have to share the jury instructions, but you will be given a copy of the jury instructions. You should think about all of the instructions as the law that you are to follow. Now, I am making 6 individual copies of the elements of the crime. Everyone will have their own. And everyone will also have their own verdict form. You may return a verdict of not guilty or guilty of weapons, firearms, brandishing in public. And the verdict form reads, the people of the state of Michigan versus Marcus Johnson. We, the jury in the above captioned case by unanimous decision, find the defendant 2 choices, not guilty or guilty. So say we all, and then the 4-person only. So even though everyone is going to have their own copy of the verdict form, only the 4-person needs to date it, print their name, and sign their name on the actual verdict form. And of course, that is only if you reach a unanimous decision. Again, if you don't reach a unanimous decision, do not write on this form and tell me whatever. This many people saying not guilty and this many people saying guilty. Don't do that. It is now time for me to pull 2 numbers. In times past, the court would pull these numbers and tell the two individuals that they are released from jury duty. That is no longer. What I'm gonna do is pull two numbers of two people who will not at this time deliberate with the full jury. However, if an emergency occurs with one of the jurors, so until the jury reaches a verdict, you are still on the jury panel. You cannot discuss the case with anyone. And if the jury, if there's an emergency and we have to replace a juror, then we're gonna call you and you have to be available to the court. So the two people that I'm gonna call, I'm not gonna require you to stay in the building. I'm gonna allow you to go, but you must give us a phone number. That is your for real phone number that we can call you on, because I sure wouldn't wanna have to do any type of hearings in case we need you. All right, so when I call your number, you're gonna write your phone number on a notepad that the officer has, and just write your jury number. You like your jury seat number, you don't have to put your name on there. Court is gonna thank and excuse jury number. Court is gonna thank and excuse jury number 6. I apologize, I said thank and excuse. The court is gonna thank jury number 6. Jury number 6 is gonna put his number on that paper. And counsel, here's the number that I pulled, jury number 6. The 6 and don't care. I know, jury number 6. Court is gonna thank and excuse jury number 4. Thank and put your phone number on the pad, jury number 4. As I indicated, if there's an emergency with one of the jurors, then we will reach out to you from a 965 phone number, area code 3, of course, 965, and then we'll give you about an hour to return to the court. So you don't have to, just don't kind of, or whatever, but we'll give you about an hour to return to the court. And then if that happens, there is a jury instruction that I will read. If you have to deliberate with a new juror because of an emergency, there's another jury instruction that I will read. Okay? For the rest of you, it is almost just tempted, maybe 6 copies. And then I'm gonna send book jury number 1, but it's not her book, like he can get them. I just wanna make sure that it doesn't have any information from the last trial in it. I don't think it does, because I used it. All right, the jury instructions are broken up. The first jury instructions that I read to you, when you first were sitting in the audience and all of that, that's series number 1. So those are toward the front. There's a second series, series number 2 in the middle. The last jury instructions that I just read to you are at the back of the book, series 3. Start with series 3 in case you want to look at that. And then we're gonna, again, everyone gets a copy of the elements of the crime and a jury verdict. Anything before I send the jurors out?
Nothing on behalf of Mr. Johnson.
How many envelopes? Because we need that.
I got a lot this time.
Okay, yeah, let's not run out of envelopes. Write a note. Write a note. Write a note. And no numbers on the note. And the 2 jurors that they are free to go ahead and cash in the voucher today. All right, then I think we're ready.
All rise for the jury.
All right, anything for the record before we recess while we wait on the jury?
Nothing on behalf of Mr. Johnson, thank you.
All right, so listen. I don't want it to take 10 minutes. If the jury come back with a no, you have to stay close by. That means at this particular time, don't go for a walk. I don't know how nice the weather is, but just don't go for a walk, just be within, 5 minutes. Go for a walk 5 minutes so that you can just keep coming back, 5 minutes, okay?
Yes.
All right, yeah, we're in recess until the jury comes. Oh, I forgot all about the case, we're in recess. I told him 5 minutes. Told that guy 5 minutes. All right. Ms. Dixon, did Mr. Bird give you any notes, cause he's gone? Did he give you some notes on Brown?
Yes, I have some notes.
But did he give you notes after I sent him the review from the update from Mr. After I get the update from Mr. Bradfield?
I'm gonna have to, listen to what, the notes are not gonna be, I don't have any more information than I had.
Oh, well then that's okay.
But I'm ready to go on.
Mr. Brown, I apologize. I apologize because I told you 5 minutes, but you were still in the breakout room and I wasn't looking at the screen because of the jury trial. So I do apologize. But, this is back on the record with. Sorry. Oh, okay, well, you might have to catch up because I'm gonna just go ahead with the court recording. No, 1904-63801. So it looks like Mr. Brown can't hear us though, because he's putting his ear up to the screen. But Ms. Dixon, I'll read this to you. I don't know, you might, okay. The first time I called the case, Mr. Brown thought he was finished with probation.
Yes, Your Honor.
Mr. Bradfield sent an update that says he still doesn't have proof of community service. He still has an outstanding traffic balance over $3,000, and he was positive for alcohol. What is he charged with? Oh, yeah, he was positive for alcohol, but that's not so bother me. Okay, so, and he didn't submit proof of the GED. So it looks like the thing specific to this case that he hasn't provided proof of is community service, and then he needs to get on a payment plan.
Okay, so, I am going to ask the court.
Mr. Brown, let me ask you something.
Yes, ma'am.
Do you disagree do you disagree about the community service?
Honestly, Your Honor, I can't remember if the community service was a part of it or not. So, I'm not going to sit up here and say that I just disregarded the community service, but I just don't remember if that was a part of what I was supposed to have done. But I felt as if I had completed everything. So, because when I talked to you, when they violated me about the alcohol, they made me come back in front of you, and you had told me like, well, that wasn't really a part of your program, so you reinstated part of my probation, so you reinstated me because I hadn't gotten in trouble or anything like that, and I had already paid all the money, and I had did my management.
So hold on.
What's on that file? It's the whole.
Oh. Yeah, the community service was a part of it.
Okay.
So let's just get them back connected, but I'll tell you this, if you get on a payment plan for the traffic tickets, I might waive the community service. You have a large balance, but, are
Yeah.
you able?
I got a job. I've been working for the last, well, when I got on probation, at first I was enrolled in the GED program. Then I got the job at the plant. So I'm not, I started working. I rather have been working so that I could continue to pay my bills and pay my restitution and all of that versus being in the GED program at the time. So I was working for 2.5 years, and then um, I was about to get a promotion. They ran my background, and then it was like that I had the warrant for the assault or whatever. I had to take care of that. So I left that job until I got everything taken care of. But in the midst of that, I began working at another place which is where I work at now. I work at Renaissance Logistics Global plant now, and I don't really have no problem with paying the money to get the tickets taken care of. I'm trying to get everything taken care of. That's why I turned myself in on the matters. You know what I mean?
Okay, so let me interrupt you. Then, okay, Mike getting ready to get this chat shut down on YouTube. Mike getting ready to get the chat shut down. In order to get on a payment plan, in order to get on a payment plan, you need $775 to, get on the payment plan. So how long is it gonna take you to get $775 to get on the payment plan?
I got it right now.
Okay, so then I'm gonna adjourn your case for 2 weeks. You come down here, sign up for the payment plan, and as long as I have proof that you're on the payment plan, I'm going to, drop the community service and close you out, okay?
Yes, ma'am.
All right. So, what's a 2-week date?
26.
How many do I have? A lot.
Are you here first?
Oh, no, I'm not here. I put no more on there. But what's the day that I have some afternoons? Do I have afternoon? Put them on April 2nd in the afternoon.
I got a court
Okay.
date third. I got a court
You
date
have a court date on the 3rd?
for the tickets. Yeah, I got a court date on the 3rd for the tickets.
Okay, well, come see me when you finish on the 3rd.
I got a court date at 8:30 on the 3rd.
Okay, well, I'll put you on my docket on the 3rd for 10 o'clock and just come see me after you, you know what I'm saying.
Yes, ma'am.
All right.
So,
It's
so am
clear on-
I had the
Yes.
money by the 3rd, ma'am?
Yeah, he says for some traffic tickets. You have court in 36th District Court on the 3rd?
I got a traffic ticket that I had court date for, and I was gonna see if I could get. I was trying to see if I could get all my traffic tickets taken care of on that date because I have.
Okay. Go to court on that day and come here after that at 10 o'clock, okay?
Okay, so don't pay the money until after I come back to you.
No, I ain't saying that. You can get on the payment plan before that. You can get on the payment plan before that. When you come to me, I wanna see you on the payment plan for the tickets that's already in the system.
Okay, I'll just go do that tomorrow morning
Okay, all right.
before I go to work.
Okay, and get you some headphones, cause you putting your ear up to get you
Yeah,
some headphones.
they told me to stand outside the car so they wouldn't think the car was moving.
Oh, okay, they put you out. That's so bold. Okay, you have a good day, stay safe.
Okay, I'll see you April 3rd.
Okay, all right, bye-bye.
Damn, I gotta go down.
Hurry up and mute him, child, cause now he's cussing. Now let me address the chat. Cause they talking about they don't know, Mike said he didn't know what he did. It's the Mike that said, 3,000 in tickets. It's that Mike, that sentence right there, Mike, you talking about, you don't know what you said, on the chat. That sentence right there, go up to where you said, 3,000 in tickets, what's that last word you said? Yeah, that's the Mike that I was just addressing, not the other Mike that said you haven't said much. I'm talking about the Mike that's using inappropriate language, even though you didn't spell it all the way out. Right, that's the mic I'm talking about. Yeah, I be watching the chat. Yes, I do. I watch just the chat. Okay, we're on recess.
Thank you very much.
I didn't snap. Y'all be misjudging me. Here we go. Now we can have a conversation. Now, why is Terry saying I snapped when I saw the chat? Y'all don't like people to address y'all. And then when we address you, now you gotta say something else. Okay, let me stop addressing, let me close the chat. Let me close the chat, because now y'all coming against me in the chat. Let me close. Let me close the chat. Let me close the chat. How much y'all didn't know? All right.
You just set it on there.
Who took that out?
Oh, yeah, I put it back in the car. Better.
Alright. I have a note. But I want something first. What's the jury instruction that I read about? For brandishing, what's the brandishing jury? No. Oh, yeah, okay.
11.25.
Okay, 11 point. 11 what?
0.25A.
I don't see it. It's a, oh, sorry. Oh, okay. Um, it says the jury would like to see all 3 videos. My question is, how long are the videos? It's a 3-part question.
video of an hour and 6 minutes. Third video is 1 hour.
Thank you. Second part of the note says, we would like clarity on what is considered a public place. And, the third part of the note says we would like more water and napkins. So I don't know about the napkins. Do we have any of those paper towels for me? We have to go get some, just ask housekeeping for some stack of those like that. So with respect to the first part of the question, it is my intention to advise the jurors how long the videos are and see if there's some specific portion of the video that they want to watch, or if they want to watch all 3 videos in full. On the second part of the question, I was looking at jury instructions to see if there was a jury instruction that defines public. So the jury instruction says what it says, and then what I find interesting, whoops, come on. What happened to all the jury? Okay. Hold on a second. So I looked in the jury instructions. There is no definition of public in the jury instruction. And I believe that it's not appropriate. Why isn't it pulling up my jury instruction the way it should be pulled up? Okay, give me 1 second. Okay, here we go. Okay, so, tell me the number again.
11.25A.
All right, so I looked in 11, the entirety of 11. There's a 11.3 definition of pistol, 11.4 definition, well, 11.3A definition of pneumatic gun, 11.4 definition of dangerous stabbing, 11.5 definition of dirk, dagger, stiletto, 11.6, strike that. And then 11.18 definition of knife and razor, 11.19 definition of dangerous weapon, 11.21 definition of negligence, 11.22 definition of willful and wanton. I don't see a definition for public place, and I don't think it's appropriate for the court to give a definition that's not listed in the jury instructions. Does anyone? Ms. Ritter says she agrees, she can't. Ms. Stevenson, what definition would the court be allowed to give a jury as to what it means to be in public?
I agree with the court's analysis, Your Honor. I
Okay.
think you just read the instruction.
All right. So I'm not going to give them a definition of public, and I believe the jury instruction, perhaps the legislature was leaving that as a question of fact. But a question of fact as to whether a person is in public. So, because it's the court, I applicant's position that if there's no definition, does that mean that a person could be on their, if I'm on private property, I can still be in public? I don't know, but I don't think it's appropriate for me to give a definition that's not in the jury instruction, so you both agree with that?
I agree with that, so I guess the biggest question would be, would that strike the Stevenson?
We're addressing jury, we're not addressing this note right now. Okay, all right, bring in the jury. And I was looking for just a section on definitions, also, just for the record, I was looking for a section just on definitions. But I do not see any definitions. Let's see. Yeah, I don't see any definition. Table of contents. Let me see something, maybe if I search. All right, that one. Oh, let me take this. Let's see. I apologize. So then, with respect to public place, I'm just gonna tell the jurors they have to rely on the jury instructions and their own confidence and everyday experience. Okay, I'm ready.
All rise for the jury.
All right, I'm gonna start. You may be seated. I received a note. That's a three-part note. I'm gonna start from the bottom up. We would like more water and napkins. We will get you water and napkins. And the second, question, so the question, we would like clarity on what is considered a public place. The answer is that you have to rely on the jury instructions that were given to you and your common sense and everyday experience. The third is the jury would like to see all three videos, and the response is, as I indicated, there are three videos. The one video is 1 hour and 25 minutes in length. Second video is 1 hour and 6 minutes in length. Third video is 1 hour in length. The question is there a specific portion of the videos that you would like to watch, or would you like to see the entirety of the videos? And that's maybe something you all are gonna have to discuss. We can show, well, we can show all the videos, but if you narrow down your request, if you want to narrow down your request, then we can do that. So I'm gonna send you back to the jury room, and then you tell me what your answer is to, do you wanna see the full entirety of each video, or can you narrow, are you wanting to narrow down your request? Okay? All right,
All rise to the jury.
build that, or get your, take that, and then get into that. Maybe, or you know what, follow me to maybe see it. I mean, we're back in recess until they come back.
Okay.
Okay, follow me to the judicial conference, let me see if it's again.
Judge, are you still posting?
I am, but I wasn't letting in that new device. I let it in. It's blank.
So. Yeah, I think it is blank.
Well, I let it in.
Okay. Okay, thank you. Okay.
It's gonna be quick. It's 12:35 and I was gonna send a note in to the jury because it's lunchtime and I don't wanna make you all. I want you to be able to go to lunch. So I was gonna send a note into the jury to let them know that we are getting ready to recess for lunch. And to ask them if they wanted to recess for lunch. They are free to deliberate through their lunch if they want to. So I was just gonna send in a note to ask them, let them know that information.
Okay,
Okay. And then I want you to wait and see what they say. So let's send in a note. Okay, the note says, the court is getting ready to recess until 1:40 for lunch. Do you want to break for lunch also? Or would you like to continue deliberating through your lunch, through the lunch break? And I'm gonna put my name. And I'm gonna put members of the. Okay, let me print this out and you can look at it. No. You hand it right in. Show that to the attorneys. Keep one for yourself. Oh, right, two, three on there. Is the note acceptable?
yes.
All right. Go pass that to the jury. Okay, what you got there?
I'm so happy to be here.
How are you?
You have no idea.
This is better than whatever else your choices were.
I start vacation on Friday, so I'm trying not to get any new cases this week.
Oh, see,
So I'm, that
this keeps you like, this keeps you off of the street.
keeps me out of the limelight.
Yeah.
If this wants to stretch till Thursday, I have no plans.
Oh, I doubt. No, listen, I can't say. If they look at 3 hours worth of video, that'll take us into tomorrow for sure.
I'll see here.
I'm coming too. Let's see what they're gonna say. I guess I should have made it clear that that means no notes will be answered. During lunch break. Oh. and see, what's the date? What date was I giving out today?
May 2nd.
Mr. Ritter, did you receive a copy of Mr. Hart's request for adjournment? He said he sent it to the people.
Oh, yeah, he did.
Right, but, I mean, I'm doing it in May. Okay. May what?
2nd.
May 2nd. Okay. Thank you. Ms. Dixon, this is what your motions should, you know, they give me a chance to deny it, approve it, you know. She's on my note, they don't keep going on that form right here. Keep going up.
Thank you, I like it.
Trying to take a second.
Yes.
And I need to answer right now. Oh, I was just going to say, they know I want to answer. Okay. Okay, so here's the responses. Oh, okay, yes, you're ready. The jury would like a lunch break. So we're gonna break for lunch, and then the response to the in-court question was that they would like to see, so Ms. Ritter, you can try to get this ready, I guess. You're gonna be the videographer. But they would like to see the video of the car approaching from the dash cam up until Officer Ayala gets out of the car. And then they would like to see the entire body cam video. We'll ask them after lunch. I believe they mean Officer Ayala, but we'll ask them after lunch. Okay, discharge the jury for lunch. We're on recess until 1:45. And then after lunch, once everyone comes, we can at least bring them into the courtroom. So what I'll do is bring them into the courtroom to view the dash cam, the way that they said, and then ask them about the body cam. Okay. Okay.
Because the other two are body cam, right?
Correct.
Okay.
And I don't know that they know that, but we'll see. Okay, we're on recess.
It's whose body cam is it?
Yeah. You think the board's gonna be okay with that? I'm getting on my. You think that the judge in front of them won't accept that? No, but I say have that.